great. Glad to hear someone.
Yeah.
What are your guys' names?
I'm Owen. This is Emily.
Nice to meet you guys. And what were you talking
Business structures and intellectual property.
Okay. What does each of you kind of do at 321? The company work at?
So we're both law students at the University of California.
Okay.
Yeah, so we're here just representing kind of the clinics that we.
Okay, my apologies.
No, no, it's fine. But we also create assistants from our clinic
Yeah.
for businesses and entrepreneurs. So
Okay.
we're just here to represent them and give a little bit
Okay.
of knowledge on just basic policy preparation.
That's really cool. If you guys want, you're more than welcome to grab some pizza.
Thanks. Yeah, we might grab some after.
Yeah.
It was nice talking to
You as well.
See
Thank you.
later.
Other states.
great.
Yeah, isn't that great?
Thank you.
Hi, everyone. Thank you all for joining us for today's session. Just to be clear, today's session is on corporate law and intellectual property for startups. So the session on go-to-market and sales is next week. But yeah, thank you all for coming. Today we have two students from the Business Venture Law Clinic. We've got Emily Zhang. Emily is currently a third-year law school student at the University of Calgary Faculty of Law. Before law school, she received an honors Bachelor of Arts from the University of Toronto. As a student working for the BLG Business Venture Clinic, Emily has helped its customers with drafting a variety of legal documents to support entrepreneurs, such as confidentiality and non-competition agreements, contractor agreements, and waivers. Emily is also the events coordinator for Pro Bono Students Canada, Calgary chapter, and is a project leader for the Hearsay podcast, which is dedicated to delivering monthly 30-minute podcast episodes through CJSW 90.9 FM, the University of Calgary's student-run radio station. She'll be joined by Ali Abdullah, who's a third-year law student at the University of Calgary, and he's also involved with the BLG Business Venture Clinic, which is the student-run clinic at the University of Calgary that provides free legal information to Calgary's entrepreneurs. So welcome, Emily and Ali. Thank you so much for joining us.
Okay. All right. Hi, everyone. So my name is Emily. This is Ali. Just a little bit more about our clinic and who we are. So as you've heard, we are both 3L students at the University of Calgary Faculty of Law. We are part of the BLG, Borden Ladner Gervais LLP, which is a law firm down in downtown Calgary. They run a business venture clinic, which essentially offers free legal assistance to entrepreneurs and businesses that are looking for legal assistance or legal information. We are supervised by Professor Bryce Tingle from the Faculty of Law, as well as a team of lawyers who mentor us in drafting our documents or giving information before we pass them on to our clients. So today's agenda, we are basically splitting the presentation into two big chunks. So the first part is on business corporations, so how businesses are structured and the corporation structure in general. And then we go into the second part of the presentation, which is discussing IP, so intellectual property and IP protection, and a bit more into detail about what specific IP protection is available to certain people, and a bit more detail about what they do, what they are, and how they might potentially serve you in your business. Okay, take it away.
Thanks, Emily. To get us started, we're going to talk about three business structures: a sole proprietorship, a partnership, and a corporation, beginning with the sole proprietorship. A sole proprietorship is when the business is unincorporated and owned by one individual, who we call the sole proprietor. The most important thing to understand about a sole proprietorship is that the sole proprietor as a person does not have a separate legal status from the business itself. In other words, the owner and the business are one and the same. A sole proprietorship is the simplest form of business organization. It doesn't require any filings or registration. And one advantage of a sole proprietorship is that you have total control of the business. You personally are able to make all decisions relating to the management and operation of the business without having to hold a vote or call a meeting. This makes sole proprietorship a mobile and agile business structure. Another advantage of a sole proprietorship is that it's a tax flow-through. And what that means is because the owner and the business are one and the same, the income of the business is the personal income of the proprietor. As a result, if your business incurs losses, then you can use those losses against your personal income. So, for example, let's say you have employment income of $60,000 and you're starting up a new business, and that business in its first year generates a loss of $10,000, say. Then you can use that loss to reduce your personal taxable income from $60,000 to $50,000. However, if your business is very successful, say it's been a few years and you've sunk your startup costs and now you're seeing a significant return, your business income will be taxed at the top personal income tax rate if you're over a certain threshold for income, and that rate in Alberta is 48%. Now let's discuss some of the disadvantages of a sole proprietorship. The biggest disadvantage of a sole proprietorship is the personal liability that attracts to a sole proprietor. Remember that the owner and the business are one and the same. And so what that means is that the debts, the obligations, and the liabilities of your business are your personal debts, obligations, and liabilities. This means that potentially creditors can come after your personal assets as a sole proprietor based on the debts of the business. On a related note, because the sole proprietorship is not a separate entity, its existence is tied to the sole proprietor. So the death of the proprietor is the death of the business. The last disadvantage of a sole proprietorship is that it's difficult to raise capital. In a corporation, you can raise money by issuing shares to investors, and essentially those investors are buying an ownership stake in the business itself. There's no analogous way in a sole proprietorship to parcel out pieces of ownership of the business to be purchased by investors. So with that, let's turn to partnerships. A partnership forms automatically when two or more persons carry on business in common with a view to profit. Like a sole proprietorship, it's a default business structure with no registrations or filings necessary. You automatically enter into a partnership when you meet that definition. Partnerships are governed by Alberta's Partnership Act, which sets some default rules for how a partnership operates. For example, by default, each partner is equally entitled to participate in the management of the partnership and to share in the profits of that partnership. However, most of these default rules can be changed by signing a partnership agreement, which makes partnerships a flexible business structure. For example, let's say you have a partnership consisting of 3 partners, and one partner is putting in way more work than the other 2. The default rule is that each partner is entitled to 1/3 of the profits, to share equally in the profits. But it might make more sense to specify in the partnership agreement that that partner who's working way harder than the other 2 is entitled to, say, 50% of, or 60% of the profits instead of the 33% that they'd be statutorily entitled to. Before discussing this last advantage of a partnership, let's turn to discuss the disadvantages of a partnership to learn how liability works in a partnership. As with a sole proprietorship, the existence of a partnership is tied to the existence of its individual owners. Section 37 of the Partnership Act provides that a partnership dissolves upon the death of any partner, but this default rule can and often is modified by a partnership agreement. The biggest disadvantage of a partnership is the lack of legal separation between the partners and the business. Similar to a sole proprietorship, the debts, obligations, and liabilities of the business are the personal debts, obligations, and liabilities of the partners, personally. The partners are jointly and severally liable for the liabilities of the partnership, meaning that each partner can be personally liable for the debts of the partnership in the full amount. Additionally, each partner is potentially liable for the misconduct and the negligence of any other partner. And on a related note, partners are each agents of one another, meaning that any partner can potentially go and sign an agreement and bind all other partners in the partnership. So that might be difficult if you don't trust each and every one of your partners. The last disadvantage of a partnership is that it might be formed accidentally. As I said before, a partnership automatically forms when 2 or more persons are carrying on business together with a view to profit. So it doesn't matter if you sign an agreement saying, John and I are not in a partnership. If you're not incorporated and you meet that test, then automatically you are in a partnership and potentially subject to the liability that we've discussed. Now that we understand how liability operates in a partnership, let's return to that last advantage of a partnership, which is that it can become limited liability. So far, we've been talking about general partnerships, but there are also 2 additional types of partnerships: limited partnerships and limited liability partnerships. Limited liability partnerships, or LLPs, are available only to eligible professions, such as lawyers and accountants. The benefit of a limited liability partnership is that a partner of an LLP is not liable for the misconduct of the other partners, so there's less liability. A limited partnership is like a general partnership, but with an extra category of partner called a limited partner. A limited partner is not liable for the misconduct of other partners and is only liable up to the amount that they contributed to the partnership. So unlike an LLP, a limited liability partnership, a limited partnership is available to everyone, not just eligible professions. And the catch there is that in a limited partnership, there has to be at least one general partner who sort of falls on the sword or is the scapegoat and takes on all the liability in the partnership. With that, let's discuss corporations. So unlike sole proprietorships and unlike partnerships, corporations are not created automatically. They're created by submitting an incorporation package to the registrar, which is very difficult to accidentally do. A corporation is a separate legal entity from its owners. The corporation can act as a person in the sense that it can buy and sell assets, enter into contracts, sue people, and be sued. Incorporating a corporation is, in some sense, giving birth to a new person, at least in a legal sense. One advantage of a corporation is that this new person is immortal. Although a corporation can be dissolved or wound up, it continues to exist even if its shareholders die. The main advantage of a corporation is limited liability, or as some call it, the corporate veil. A shareholder of the corporation has no personal liability beyond their personal contribution. In other words, if you invest in a corporation and you receive an ownership stake in the corporation, generally the worst case scenario is that you lose your initial investment. By contrast, in a partnership, your liability is personal and unlimited. This idea of the corporate veil applies even if you're the only owner of the corporation. The liabilities of the corporation are the corporation's alone. They're not your personal liabilities, and they overlap only to the extent that you invest money into the corporation. Continuing with the advantages, it's also easier to raise capital in a corporation. As I mentioned earlier, a corporation can raise money by issuing shares to investors so that the investors are purchasing an ownership stake in the business. Now let's discuss the disadvantages of using a corporation. Firstly, there's a potential for the founder to lose control of their business. So if the founder owns the majority of the shares in a corporation, then they essentially can directly elect the board of directors and directly pass shareholder resolutions. And so if the founder owns the majority of shares, they essentially control the corporation. However, if the business needs a lot of money, it might make sense for the corporation to approach investors and issue them enough shares or give them a large enough ownership stake that the founders end up losing their majority shareholding in the corporation. As a result, the founder might get outvoted when electing directors and subsequently lose control of the company. Another disadvantage of a corporation is that so-called corporate governance can require time and money. In order to properly administer your corporation, you have to call shareholder meetings, call board of director meetings, draft and pass resolutions at these meetings, record meeting minutes, keep corporate records, the list goes on. And then when you're incorporating, you have to assemble your incorporation package and pay a $200 fee to the registrar. And once you're incorporated, there are various compliance and filing requirements. So all of this can be kind of a cumbersome process, especially when you contrast it with a partnership or a sole proprietor where there aren't analogous filing requirements. Lastly, corporations also have a complex tax structure. In Alberta, the combined small business tax rate is 11%. So after your corporation earns income and it's taxed, it becomes retained earnings of the corporation. And then out of those retained earnings of the corporation, you can declare dividends to be paid to your shareholders. The shareholders are then taxed on this dividend income, and the taxation of dividends can get pretty complicated. One might instead consider compensating themselves through a salary if they're also an officer of the corporation or otherwise employed by the corporation. But regardless, corporate tax is a complicated area. And you can compare this to the tax flow-through of a sole proprietorship, where it's simple. The income of the business is the income of the sole proprietor personally. So we've gone over these three basic business structures. Does anyone have any questions? Yeah.
On top of the $200 fee, how much does it usually cost? Because like, yeah, I assume this package is usually drafted by lawyers and whatnot, so how much is the usual price for incorporation?
So
Big question.
yeah, there's the articles of incorporation need to get drafted. Oftentimes there's bylaws as well that govern how the corporation like internally governs its affairs. And then there may also need to be, I think it's called a registry agent, someone, basically another address for service, so legal documents. Getting all of that done is in the mid to high hundreds of dollars. I can't give an exact number, but like probably or less than $1,000, depending exactly on your business needs. Yes?
Is it easy to switch from, say, a sole proprietorship to a corporation, or a partnership to a corporation, or vice versa?
That's a good question. I think that we'll discuss maybe on this slide. The majority of new ventures in Canada start off as sole proprietorships. And I think that that's pretty common for businesses to start off as sole proprietorships or unintentionally as sole proprietorships as partnerships. And then as the business matures, to realize that, hey, we're taking on some liability here, we're hiring employees, it would make sense to formalize structures and incorporate. So I'd say for a company that maybe is already somewhat sophisticated and has entered into contracts and is employing people and is still in this a sole proprietorship or partnership, it might be a little bit difficult, but it's very common, and I don't think that there's any like major issues with incorporating later on. So, yes.
Can you comment on the documentation required for things like a shareholders agreement that would be involved if you do have shares issued in a corporation between potential founders and investors coming in?
That's another good question. So, when you say documentation,
Shareholders agreements, there's multiple things that can be covered by that statement. And what should people be aware of with it? You just mentioned filing documentation to the registrar, but there's other things that go around forming a corporation that don't necessarily need to be filed, but you still need to have, such as the shareholders agreement,
yeah.
or founders agreement, or other things like that.
I think that's something that a lot of people don't know about is just the resolutions that need to get drafted as well. When a corporation is first formed, there's a lot of initial business that needs to be done, and so directors' resolutions need to get drafted, and minutes of the meetings also need to get drafted as well. In terms of the shareholder agreement, that governs sort of the relationship between the shareholders and how shareholders may alienate their shares, buyback rights, piggyback rights, like what happens when there are disputes between the shareholders. So I'd say, bylaws are also an important part of that, but I don't know, nothing's coming to mind beyond that. Emily, do you have anything?
We'll go into a bit of the documentation details later, but essentially there's certain documents that are required by the law, and then there's certain documents that are good practice to have. So we technically don't need minutes, but it's just good practice to have so you can keep track of your things. But otherwise, I believe just bylaws and articles are required by law. When you incorporate, you don't necessarily have to have them, I believe, in terms of just how the government has structured their registration process. But you should have it because it's legally required of you. Everything else is more just depending on your business structure.
I'll add that for an incorporation package, you need a notice of address, and you also need a nuance search report. So if you're using like a business name, for example, there needs to be a special search that you pay a nominal fee for in order to make sure that like no one else is using that name and it's available and all the rest of it. So yeah, lots of documents, and Emily will go into that in detail shortly. Any other questions? All right, moving on. Why incorporate? You'll see here that most new Canadian businesses are in the form of sole proprietorships, 64%, or partnerships at 20%. And only about 11% of new businesses in Canada begin in an incorporated form. side note, if you're wondering why those numbers don't add up, there are more than 3 types of business structures, which we're just only dealing with 3 today. But there are things like joint ventures that are in that weird 5% that's missing here. So only 11% of new businesses begin in an incorporated form, so it's relatively rare. But this changes as the revenue of the business increases. Nationally, incorporated small businesses see revenues rise by 40% more than unincorporated small businesses. The point here is that as revenues rise, the business gets more sophisticated, and so it makes sense to adopt a more formal structure. Now I'll turn it over to Emily to discuss when someone should incorporate.
Thanks. So yeah, Ali's gone through quite a bit of the reasons of when and why to incorporate, but just to kind of give you a bit of more detail in a broader sense. So the first is to avoid personal liability. So as you heard from Ali, when you're starting as a sole proprietor, all of the liability, worst case scenario, someone sues you, you are personally responsible. Your own assets, your bank accounts, those are all part of your business, regardless of whether or not you actually use those for your business. So you do have more personal liability. So if you want to avoid that and you realize that perhaps you're taking on more than you can chew, the general practice is to incorporate your business because it creates that separate legal entity and it doesn't touch your own personal assets. The second is when your business is becoming more profitable. So if you're seeing more returns on your business than you're actually losing money, again, general practice is to incorporate your business because there's more beneficial tax benefits. Especially if you're getting active business income over $500,000. The third reason is for external investors. So if you want to get money from elsewhere, and it could be a stranger, it doesn't necessarily have to be from your friends or family, you would want to incorporate because more so for the benefits of your investors than yourself. But there is a risk of your investors also being found personally liable if your business is unincorporated. Because kind of going back to what Ali was saying about the partnership, as long as these investors are involved in your business, if you're unincorporated, they potentially could be part of your partnership, whether or not you intended that. The fourth is hiring employees. So employers are generally liable for their employees' actions, and incorporation avoids personal liability. So again, going back to the whole involved in the business, perhaps in your head you want to hire these employees, you have a drafted contract for them, but if you're unincorporated and something goes wrong with that employee, they could still hold you personally liable, and they could be found personally liable for your business as well. So corporate structure, we kind of threw these terms around earlier, so some of you might already know these, but essentially shareholders, these could be the owners, these could be founders, these could be employees, but these are just the owners of the company. They hold shares in the company, so they hold value to that company. So they own shares in Example Corporation. The shareholders have certain voting rights. Not everyone has the same amount of shares. Not everyone has the same amount of voting rights or power. That is determined by kind of what we said earlier, based on articles and bylaws of how you structured your corporate business. Those shareholders then have the power to elect the board of directors. These board of directors are the ones making the decisions of the corporation. So it's not necessarily the shareholders. While the directors are accountable to the shareholders, right, they want to benefit what the shareholders want, the board of directors ultimately make that final decision, and it has to be unanimous. These board of directors then appoint a CEO, kind of think about the representative of the company, right? Like you see in the newsletters, the CEO this, the CEO did that, or the CFO or the COO. Those people who hold the titles are kind of like the face of the company, right? So they can make certain decisions, but again, they also report to the board of directors. All right, so going to the corporate documents that we talked about earlier. These are the main documents that you kind of want by law. So there's the Articles of Incorporation, which is the governing document of the actual corporation, the company. So this is setting how shares are distributed, how many number of shares, what each share is worth, which ones are voting shares, all of that. Bylaws and resolutions is how the company is run. So for example, how do you hire employees? How does a shareholder leave? This can be amended or repealed by any ordinary resolution. So again, as you have annual meetings, as you should, based on your articles and bylaws, any resolution that you reach should then be incorporated into the bylaws and resolutions. But again, these are just how the corporation runs. Shares are, some of you probably heard of a cap table, right? It's just a visual demonstration of how shares are distributed. So there could be Class A, B, C shares, common shares, preferred shares. Usually preferred shares are given to the founders of the corporation, the ones that hold a bit more voting rights, and these define the rights of the owner. So again, is there a specific type of Class A? No. How you define Class A, B, C shares, common, preferred shares is completely up to the actual shareholders and the founders of the company. Okay, so founder proofing. What is it? So it's basically tools that you have that you want for yourself as a founder of a company to protect yourself from possible liabilities or conflicts. That includes arguments between the founders, it includes founders leaving, it includes introducing new founders to the company. So again, the reason why you want to do it is just good practice, right? Eventually, no matter how close you are to your founders, there are going to be potential arguments, there are going to be disagreements. So you do want some kind of legal backup to support your decisions that you can rely on. So here are some ways to founder proof. The first one is to give founders different equity amounts to reflect different roles and contributions. So Ali was saying earlier how, not everyone's going to contribute the same to the company. Some might do more work at the forefront, right? Create a website, draft the documents, incorporate the business. Some might do more client-facing roles, right? Like actually trying to find investors, sending out emails, being the administrator, going to the banks. The general practice that we tend to suggest against is to have a 50-50 amount. If there's two of you, try to avoid equal shares because then if there are any problems, you are at a standstill. You have 50-50, no one says anything against one another, you're kind of stuck at a standstill. So avoid 50-50 for that reason. The second is to allocate responsibility to people best suited for the roles. Kind of a obvious point, but sometimes it doesn't always come across to people. You want to make sure that the people who are in charge of certain tasks actually know how to do those tasks and are willing to do those tasks. So if someone has a business background, you don't necessarily want them, handling the financial assets of a company. If someone is only there in the founders because they know how to build a website, you don't necessarily want them, making a business plan for the company. The third is to avoid high-risk, high-reward structures because it's just difficult to avoid strategic behavior and remove problem founders. So basically what we mean is, invest a crap ton of money into a business and then hope that all of it's going to get returned to you sooner or later. Again, you want to avoid this because once people lose a certain amount, right, if they can't get that back, then there's going to be a lot of conflicts between you and those other people. The fourth is to set up a formal, effective board of directors. Again, kind of obvious, but sometimes not really, because usually startups happen with people that you're close with, your friends, your family, your classmates. You kind of go in with this intrinsic trust of a person, but again, you want to follow good legal practices by setting up a formal board of directors, mostly separate from the founders. That way they can make their own decisions that reflect your values, but again, they're their own separate entity and there's not a lot of crossover, so there's less conflict between the actual founders. Okay, yes?
On the point regarding high risk, high rewards, so does that refer to a compensation structure wherein the salary component is much less and the compensation is primarily based on equity? Is that?
It's part of it, right? Because you're putting in a lot of risk when you're first starting out the company. It's common, right? Because at first when you start a business, there's not a lot of equity that's in the company, right? You're putting in your own money into the company, so you're not really sure how much profit you're actually going to get. So that counts as high risk. But again, you want to make sure you structure everything legally, like out in the documents somewhere, so that you can refer to that if things go south. Yeah. Any other questions before we move on to IP? Okay. All right, Ali, take it away.
Thanks. Now let's transition from our conversation about business structures and founder proofing to now discuss intellectual property. And first, let's ask, what is intellectual property? Intellectual property, or IP, is property resulting from human intelligence or creativity. Some examples of IP protections include copyright, patents, trademarks, industrial designs, and trade secrets, and we'll discuss each one of those in turn throughout the rest of our presentation. But first, let's discuss the benefits of IP protection. Firstly, protecting your IP allows you to establish ownership over your intellectual creations. You can then license others to use your IP for a fee. Secondly, if your competitors don't license your IP, then they won't be able to use it, and they'll be at a disadvantage in the market. You'll have a competitive advantage over them. Thirdly, protecting your IP protects your business identity. Thirdly, protecting your IP protects your business's identity, image, and reputation. So this mostly deals with trademarks, for example. If you've been in the market for a while and you've built up goodwill with your customer base and there's a positive association with your business's name, you'd want to prevent another business from riding on your coattails by using that same business name. Now, let's turn to discuss copyright. Simply put, copyright means the right to copy something. More precisely, the copyright holder has the exclusive right to reproduce, publish, or perform the subject matter in question. For example, the author of a novel or the composer of a musical score automatically holds copyright in their work without any registration or filing necessary. Note that copyright protects only the fixed expression of an idea, not the underlying idea itself. So, for example, the actual text of Twilight and not a generic story about a romance with a vampire. But what exactly does copyright apply to? Copyright applies to two categories of materials, works and other subject matter. If you have a problem with that second term, blame the Copyright Act, not me. Works are further subdivided into four categories: literary, artistic, musical, and dramatic works. Literary works include books, computer programs, databases, and other text. Artistic works include schematic designs, photographs, paintings, drawings, and sculptures. Musical works include compositions with or without words, and dramatic works include films, training videos, plays, screenplays, and scripts. The second category of other subject matter is kind of a mixed bag, and it includes sound recordings and communication signals such as radio waves. Now that we know what copyright applies to, let's ask, who owns the copyright as between an employee and an employer? So the employer is the copyright holder if the copyrightable material was produced in the course of employment. However, the employee is the copyright holder if it was produced outside of the workplace, it was created on the employee's own time, and it was not within the true scope of employment. When dealing with outside contractors, so not necessarily employees, but outside contractors, it might be prudent to include a contractual assignment of copyright in the contractor agreement, basically saying up front that the company or the employer owns the work and thus the copyright underlying that work produced in the course of employment or in the course of that contractor's duties. Now let's discuss patents. So a patent is a limited monopoly for invented technology in exchange for public disclosure. In human language, a patent is an exclusive right to commercially exploit your invention in exchange for you telling the world about your invention. And this right lasts for 20 years from the date you file for your patent. But what is patentable? Sorry, I should say what is patentable, not copyright. For an invention to be patentable, it must be new, useful, and innovative. For the invention to be new or novel, you must be the first person in the world to have invented it, at least as far as anyone knows. And this one-year grace period refers to the fact that essentially, once you disclose your invention to someone, you have 1 year to file before you lose the right to file your patent. For the invention to be useful, it simply must have some practical benefit, and it must actually work. For the invention to be innovative, it must not be obvious to workers of average scale in the industry. In other words, the invention must actually improve upon the prior art or the prior knowledge in that industry in a way that's more than merely obvious or trivial. There's some inherent ambiguity about what constitutes a sufficiently large leap from the knowledge of the industry to actually result in a sufficiently innovative invention to be patentable. And that's the subject of lots of interesting patent litigation. In terms of content, the invention can be a new or improved product, composition, machine, or process. But who has the right to file the patent application as between an employee and an employer? Here, the right to file the patent is presumed to be held by the employee. However, the employer has the right to file the patent if the employee signed a contract assigning IP rights to the employer, or if the employee was hired for the express purpose of inventing and innovating, or if there's a fiduciary duty that the employee owns the corporation. And just a little bit more about that. This would be a case where the employee is senior enough that they actually owe the corporation a duty to put the interests of the corporation before their own personal interests. That would result in the corporation or the employer owning the IP, potentially. Because this can be an uncertain and contentious area, if you're an employer, it's prudent to include a contractual assignment of any patent rights in the employment agreement, basically saying upfront that the employee assigns to the employer any patent rights that might arise during the scope of employment, or during the term that they're employed, rather. But why apply for a patent in the first place? A patent is a valuable asset. It allows the patent holder the exclusive right to commercially exploit the invention. The patent holder can use the underlying invention for commercial gain, or they can use the IP right to either sell it or license the patent. In either case, owning a patent is attractive to investors as it signals that the business owns something exclusive and valuable. Additionally, applying for a patent helps enrich knowledge worldwide. This is somewhat of an altruistic argument, but a description of your invention will be accessible on the Canadian Patents Database 18 months after filing, which may lay the groundwork for others to innovate, presuming that they appropriately license your patent. Note, however, that patent applications are national. That would go, for example, we're in Canada, to the Canadian Patent Office. And that if you would like to have your patent rights enforced in another jurisdiction, you'd need to file for a patent in that other jurisdiction, say US or China. And continuing to pay, for example, an American and Chinese patent officer might be logistically complicated and perhaps costly. So there are potential downsides to disclosing your patentable invention. If you decide not to patent your invention, you may consider the option of having the invention remain a trade secret, and Emily will talk more about trade secrets later. Now let's discuss licensing IP. As we've discussed, licensing your IP is a positive signal to investors that your company owns something of value. Additionally, licensing your IP gives you leverage over other market participants. Either pay our licensing fee or you'll be at a disadvantage in the market. Many startups fail to obtain the IP that's integral to their business. Instead of the corporation owning the IP, perhaps a founder personally owns the IP, or the IP is owned by some third-party company. This is a mistake from a business planning perspective, because investors, by and large, want to know that the company owns the IP directly in order to ensure stability of the venture. They don't want the corporation to suddenly lose the IP right that's foundational to their business. And this also goes to Emily's earlier point about founder proofing. It's important for the longevity of the business for the company to own the IP itself. So before I hand it over to Emily, does anyone have any questions? If not, yep.
So you mentioned you've had a patent for 20 years. What happens if you don't pay the continuation fees?
That's a great question. I have no idea.
Pretty sure you just lose the patent, or you lose the legal right to that specific thing. Yeah.
Yeah, I think it basically becomes withdrawn if you don't pay the fees.
Right. If there are no other questions, I'll hand it over to Emily to continue our discussion of intellectual property, and in particular, oh, never mind.
Can you share some light on how patents are there to software?
What was that, sorry?
How
So yes, there are potentially cases where software can be patented. In terms of the intellectual property protections for software, it's far more likely that software, just to go back to our slide on copyright here, so the normal situation is that software is a literary work, so that's under computer programs. And so when you're licensing software, that's normally how you would do it. You'd be licensing the copyright rather than the patent right. However, there have been cases where patents have been issued for software, but it's not necessarily for the precise fixed expression of the software itself, the actual lines of code. To go back to this slide, in the cases that I've read at least, it's a business process. So that last bullet point on the right side, it would be a business process. So there's no separate sort of category of software itself. It would either be a literary work under copyright or it would be a business process under patent law. But yes, that is a thing. There, Amazon, for example, holds software patents as a business process. So. All right, if there are no other questions, then I'll hand it over to Emily to discuss trademarks.
Okay. So trademarks, they're basically identifying mark that distinguishes a business product or services from its competitors. So there's a difference between an ordinary trademark versus a certification mark. So an ordinary trademark is just, for example, if there are specific production process, sights, smells, taste, anything that you want to basically claim as your own or your business's, that would be an ordinary trademark. But a certification mark has a bit more of a broader legal protection. So for example, toilets, they have to be produced to a specific standard that falls under law and regulations. So if you're able to apply for a certification mark or you see a certification mark somewhere, that basically just means that the product or the service meets that regulated standard. So the legal test, usually to determine whether or not a trademark is feasible, is distinctiveness and whether or not there are confusingly similar names or marks that an ordinary consumer can tell. So basically, can an ordinary consumer distinguish between like a similar name or a mark that you are trying to trademark? If they can't, then you cannot trademark it. This is a 15-year term. It's renewable. And the priority with trademarks is what we call first use. So basically, first come, first serve. If you are able to prove that you are the first to use or show that you have implemented your business or your services or a product before someone else, usually you get priority over the other person who is trying to claim the same trademark. So again, what does trademark cover? So new or improved useful inventions. It could be a word, a phrase, logos, shapes, certification mark as we discussed, color, smell, sounds. Things that it does not cover includes names and surnames for obvious reasons, clearly descriptive marks or deceptively misdescriptive marks, geographical locations, words in other languages, words and designs that are confusing with registered or pending trademarks, because again, you have to go through a registrar, or words and designs that look very similar to a prohibited mark. So anything government owned, for example. So why get a trademark? Of course, it distinguishes your goods or services, and it builds reputation in your corporate image. So kind of circling back to the reasons that Ali was describing. Overall, is just general good practice for your business to have something to show to your users or your consumers that, hey, this is something special that belongs just to us. So here are a few trademark disputes to kind of give you guys a few examples. The first one is between an artist who launched his own clothing line that basically over the pandemic, he created this logo source that's called Be Boss, Be Kind. He would end a lot of his artist, like online artist lessons with Be Boss, Be Kind, just kind of as an inspirational quote to his clients. And when people started asking for, merchandise for it, he was like, yeah, sure, why not? Let's actually make something with this phrase. However, when he actually registered this as a trademark, he actually got a letter from Hugo Boss's lawyer saying, hey, you can't do that. They're going to confuse your brand with our brand because it has the word boss in it. So the company essentially wanted to block his application and said that they would drop the action if he withdrew it and then would actually stop selling his items. So I think the result actually came out, but basically this family got together with the negotiations with Hugo Boss's lawyers, and they agreed to stop selling their products. So in a way, Hugo Boss won. However, this kind of just goes to show that you can't just willy-nilly produce something, even if you think it's not remotely similar. But I don't know, you can't put Boss in your names. The other one is a trademark dispute between Monster's Energy Drink and a company called Thirsty Beasts. So Thirsty Beasts had a slogan called "Rehab the Beast," and essentially they were a healthier soft drink alternative that was targeted towards children. However, when he filed for a trademark, Monsters Inc. Drew an action against him because they were saying that his slogan is going to be confused with their slogan, which is "Unleash the Beast." However, Mr. Smith, the owner, actually won this case. So he's still able to use the "Rehab the Beast" slogan, but the reason why we put this on here is to remind you just how costly it could be when you're having these disputes. So Mr. Smith actually lost, I think it was like £30,000, which is 50,000 Canadian dollars in legal fees alone, just to fight against Monsters Inc. So yes, you can fight against these big companies, but you have to also consider the legal cost. All right, so moving on to industrial design. So this is specifically protection that's centered on the shape, pattern, or ornamentation of a product. So the shape of a vehicle. If anyone knows what an Eames lounge chair is, it's just kind of one of those, you kind of see it at like a therapist's office, but it's like a black leather chair with wooden accents and like a little leg rest. But basically just very specific products that you can kind of distinguish just based on its actual shape. So product aesthetics. It has to be original novel, and it's protected for a term of 10 years. So an example is the industrial design case between Apple and Samsung. A little dated, but some of you might actually remember this. Samsung came up with their product design on the right after Apple came out with theirs, and Apple basically sued Samsung by infringing on their patent designs. So this is differentiated from patents themselves because these are design patents that falls under industrial design cases. So Apple had these 3 patents, those 3 serial numbers. The first 2 covers the actual shape, rectangular shape of the iPhone, the circular home button, and the actual grid outline of the icons. And the third patent covers the actual rounded square icons of the interface. So Apple sued Samsung on infringing on those 3 patents, and they actually won. So Samsung had to pay Apple all of the profits that they got from selling this specific model, which usually isn't the case for some of these legal cases, but considering how this dispute was between 2 very large corporations, the California court ordered that Samsung paid all of their profits back to Apple. Thirdly, trade secrets. So Ali was mentioning this earlier, but trade secrets are just anything that's confidential or secret information that your company wants to keep to themselves. So this includes technologies, formulas, recipes, something you might want to patent in the future. It could also be client or customer information. So trade secrets, there aren't any legal protection over those per se, like you can't file to a registry to list something under trade secrets. So that's one of the risks in terms of maintaining a trade secret. However, the benefits are that they never expire. Again, there's no filing or government approval, so that could be a benefit depending on your business. And they can help protect your inventions before to actually patenting them. So if you're designing something that still hasn't necessarily been produced, you can consider that a trade secret. However, that does lead to risks. So it could be expensive to maintain. Because there are no filings to the government for this approval, you have to maintain your trade secret through things like contracts, security, just overall business governance. However, the other issue is once it's actually exposed, it's no longer actually a secret, right? You can potentially, so for example, if you have an employee, you have them sign an employment contract. You can technically sue that employee for breaking their contract because they leaked trade secrets. However, at the end of the day, your trade secrets are now leaked. So do you go after that employee for that reason, or do you just try to continue business and beat other potential competitors in the market? So not everything can be protected, and it can't prevent a third party from independently coming up with your secret. So if a third party just decides one day that they have a brilliant idea that you have, you can't stop them. So kind of going back to the contract protections. So some considerations is that, the information of commercial value is not disclosed to the public. So obviously you have not actually given this secret out to the public. The value is at least partially linked to the fact that it is not known, right? So potentially you have a benefit in actually keeping it secret. So for example, you can think of Coke and Pepsi. Potentially their recipe is a trade secret, right? And then efforts have been made to maintain secrecy. So there's some value behind keeping this a secret, and you've actually put in some action to keeping it a secret. So contractual obligations are things like non-disclosure documents, non-competition documents, and non-solicitation. So just a brief definition of what those are. Non-disclosure is kind of what it says. You sign this agreement with someone else, and that person agrees not to disclose your information to third parties or whoever else you specify in that agreement. Non-competition usually means that the person signing it cannot compete with you in this industry for a certain amount of time. Usually it's around 1 year, depending on what it is you're protecting, but the court generally tends to keep it within 1 year because they want to have healthy competition in the industry. And non-solicitation, as it says, you've probably seen these in some of your employment contracts, but if you have a person who leaves the company, they cannot take your employees into their company that potentially could have the same benefits of your company. So, in summary, there are 4 approaches to protecting your IP. There's trademarks, patents, copyright, and industrial design. And to protect IP, you have to determine which part of the product you actually want to protect. These rights can happen before you even register, right? So again, going back to the industrial design and trade secrets, if you've actually put an effort to protect your designs or your products, you still potentially have the legal right to those to that protection, regardless of whether or not you've actually registered it with the government. Again, registering for protection of IP can be complicated, expensive, and unnecessary. So really, we as law students, we're kind of meant to tell you to go see a lawyer for any future legal advice, because sometimes you don't even need a patent or you don't need protection. Again, it depends on your business. So that's it for our presentation. If you guys are interested in contacting us specifically or the clinic in general, we've left a few business cards and just some general marketing things on the table. So if you want to take that for your future reference, you can. Additionally, if there are any other questions, we're happy to answer. There's also a session feedback QR. So if you could scan that if you want to put in feedback for us, that'd be great too. But any other questions?
Would you like to comment on patent trolls?
Patent trolls?
Yes. What is it, and how does your patent actually protect you against patent trolls?
Patent trolls. I've actually never heard of that term before.
So my understanding is that patent trolls are kind of like companies that most of what they do is aggregate patents, create a patent thicket, and then when someone is operating a good and legitimate business, say, hey, you're infringing upon our patents, we're going to try and license these to you for an exorbitant fee, and then that's that's basically their business model. I would say that in terms of mitigating against that, you would want to perhaps be first to the punch on it. Other than that, I think that a lot of the patents held by these companies are of dubious, innovative quality, and so it might be worth challenging the validity of those patents in the first place, but other than that, nothing really comes to mind.
Any other questions? Yeah?
For the non-solicitation, does it include referrals as well, or just the...
It could. So all of those agreements, you can always cater them to your specific business needs. So if you think referrals are potentially a threat to your business, you can add referrals into that agreement. Yeah. So again, you just have to look at the details of the actual agreement, yeah. Okay, anything else? Allie and I will also stay behind for a few minutes if you do want to talk to us personally, but otherwise, yeah, thanks for listening, everyone.
sorry for all the questions. Bryce helped present my company. So I've used you guys years ago. That's awesome. I don't really started as a capital. But yeah, no, sorry.